Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So just a couple days ago I made a video talking about a major victory at the Ninth Circuit Court of Appeals in a case called Nguyen v. Bonta, which challenged California's 1 in 30 law. This case was decided by a unanimous 3-judge panel decision that said that California's law was unconstitutional, and we were all waiting to see whether or not California would ask for an en banc rehearing, which basically means that a larger portion of the Ninth Circuit would essentially rehear this case. And it never happened. The deadline came and went, and California never filed. So that major victory stands. California's 1 in 30 law is done. But just later, the next day, we got bad news. That another major case that is currently up at the Ninth Circuit is now in kind of jeopardy. And we need to talk about it today. We're talking about Rhode v. Bonta. This is the ammunition background check one. Let's get to it. Now, if you're watching this video and you're not yet subscribed, one of the best ways to support this channel is simply by hitting that subscribe button or scanning the QR code. It's free, it only takes a second, but it really does help us out here quite a bit. It helps us spread our message, it helps us grow, and it helps us in our Second Amendment advocacy. So thank you to everybody who subscribes. Okay, so let's go ahead and talk about what's going on here. So like I said in the beginning, we're talking about Rhode v. Bonta, which is a case that challenges California's ammunition background check scheme. The same scheme that says you're not allowed to have anything sent directly to your house. You have to go through a background check for every single transaction and pay a fee, unless you're not in the system, in which case you have to pay an even larger fee to do the background check. You get a lot of false positives. I have had law enforcement officers that are, these are active duty law enforcement officers who have had false positives and been denied because something wasn't right with the system. I mean, this thing has created more false positives than it has actually catching anybody trying to do anything that they're not technically allowed to do. It's completely unconstitutional. It is an entire mess. It has been a mess since its creation from Prop 63 that unfortunately the people of California voted for, as if somehow you're allowed to vote your rights away. Now, after waiting for years, we finally got a decision from a 3-judge panel at the Ninth Circuit Court of Appeals, and even though it was not unanimous, the court still found that California's law was in fact unconstitutional. Now, that led to some kind of chaos afterwards. People wondering if this was going to be like a second Freedom Week. There was companies out there that were sending things in as fast as they could until the California Department of Justice sent out a memo and kind of shut that whole thing down. Now, we were all waiting to see what California was going to do about it, and unfortunately, on August 7th, the California DOJ decided that they were, in fact, going to petition the Ninth Circuit for a rehearing en banc. Now, even though they decided to back off Nwin, the very next day they decided to move on with Rhode, which is fascinating to me because California's law is clearly unconstitutional. There is no historical relevant precedent for California's law as it stands today. There is nothing in our nation's history and tradition of firearms regulation that is even somewhat similar to what California is trying to do, where you have to do a background check for every single transaction, pay a fee for every single transaction, basically have the state control one of your rights through fees and regulations. There's nothing like that. I've read the entire Second Amendment. At the end it says shall not be infringed, period. There's nothing that comes after that. But California seems to think that, you know, some analog that has to do with storage of powder is going to be enough to challenge this, which is crazy. Plus, they also think that because the people voted for this, somehow that makes a difference. That's one thing that California has leaned on. Because this is Prop 63, because it was passed by the people, somehow it should be allowed to stand. That's not the way things work. If the people of California passed a law saying that nobody's allowed to go to church anymore, that wouldn't stand because it's still unconstitutional, even though the people voted for it. But this is going en banc now. So what does that mean? Basically means that a larger portion of the Ninth Circuit Court of Appeals is going to rehear this case. They're obviously going to consider the district court's decision. They're going to consider the 3-judge panel's decision and the dissent. They're going to look at everything, and then that larger panel is going to come out with their very own decision. So in the past, this has not worked out really well for us. Usually when we go en banc at the Ninth Circuit, they tend to side with the state. So it is very likely, just based on the history that I've seen reporting on this stuff now for the past 13 years, that they're going to, again, side with the state of California. If they don't, fantastic. But they could very well side with the state of California. Now, the other option is, even though they appealed en banc, that doesn't mean the Ninth Circuit actually has to rehear it. The Ninth Circuit could end up declining that petition and just let the three-judge panel's decision stand. I don't think that's very likely either, but it is a possibility. Now, if we end up losing en banc, we could always take this up to the Supreme Court. They're not really great at taking things, but it is possible that they could take something like this. Now, on August 8th, the Ninth Circuit asked the plaintiffs to respond to this request for a rehearing en banc. They gave them 21 days. So they have 21 days from August 8th to reply to that petition where they can essentially argue their case why this shouldn't go en banc. And so we'll see what happens. But again, that's not due for another 3 weeks. So it's going to be a little bit before we actually find out whether or not the Ninth Circuit has decided to take the case or decided to deny it and let the three-judge panel stand. So it's going to be a little bit of time before we hear anything more about this. But I wanted to kind of keep you up to date and let you know what's going on with Rhode, because it was nice to see the win in Nwin. It was nice to see the win in Nguyen. But now we want the win in Rhode, right? We want that win to stand. We want the mandate from the court telling California, knock it off. You're not allowed to enforce this anymore. It's unconstitutional. You're done. And that would take care of the 1 in 30 and the background checks. That'd be fantastic. So if anything else changes or something happens, I will let you all know about it. I want to thank you all very much for watching. I really do appreciate it. You all have a great day.